Dumelang! Welcome to my channel, Botswana Thinking Law, where I bring you and the law closer. Do you know enough about appeals to the Court of Appeal? In this video, which is part 1 of challenging court decisions, I will be talking about appeals, and these are civil appeals, from the High Court or Industrial Court to the Court of Appeal. In part 2, I will be talking about rescission and variation, and in part 3, I will be talking about judicial review. But before we get started in this video, I'd like to put in a disclaimer. This is not legal advice. This is simply a sharing of general information. If you have a problem of a legal nature, please engage the services of an attorney. Now back to our video. As I said before, we're going to be talking about civil appeals from the High Court or Industrial Court to the Court of Appeal. An appeal can be as of right, or an appeal can be by leave. An appeal that is as of right is where a person has a direct way of going to the Court of Appeal. And this is usually from a final order of the High Court or Industrial Court, where the High Court is a court of first instance. In this situation, I'm talking about where the High Court is the one that starts the matter, or the matter is started first at the High Court. And if it's such a situation, then the person has to, within 6 weeks of a decision being granted or being made by the High Court or Industrial Court, to have filed their notice of appeal as well as the grounds of appeal. And these grounds of appeal would be where they say why the judge, in making whatever decision they made, they were wrong. If they bring the matter after 6 weeks, they have to bring it before the expiry of 3 months. They have to bring an application for leave to file their appeal out of time. And in that application, they have to firstly explain why they're bringing their appeal out of time, and they have to show that they have good prospects of success. Inside their application, they have to put in the notice as well as the grounds of appeal they intend to use if their application is successful. If they want to bring the appeal after 3 months, then they have to show exceptional reasons for why they were out of time. And an example could be that they were hospitalized. They have to show strong prospects of success as well as include their notice and grounds of appeal in that application in case they are successful. They also have to serve this application on the people that they intend to be suing, that is the respondents. And the person who brings the appeal would be the appellant, but because the appeal is not yet there will be an applicant. Now let's talk about appeal by leave. This is where, if you are at the High Court or Industrial Court, you have to ask this court to be allowed to bring an appeal to the Court of Appeal. And if the Industrial Court or the High Court refuse, then you can bring that application to the Court of Appeal. Situations where you have to ask for leave to appeal are where the decision is in relation to an interlocutory matter. An interlocutory matter is where you have one full matter. Let's say it's a debt collection, and then right in the middle of that matter, you bring an application for a specific thing. If you are not given that order, then you can ask for leave to appeal that refusal. You can also ask for leave where you are challenging an issue of costs only. Maybe you were successful, but you were not given costs by the court. or you were unsuccessful and you feel that the costs that the court has given the other party who was successful are too high. If you intend to challenge the issue of cost only, then you have to ask for leave. You can also ask for leave where an order or judgment was given by the High Court or Industrial Court where the parties agreed, where it is called a consent order, or where the High Court is sitting as an appellate court. Maybe a matter goes to the High Court on appeal from the Customary Court of Appeal or from the Magistrates Court. Where the High Court is sitting as an appellate court, then you have to ask for leave to file to the Court of Appeal in the event you are not happy with the decision of the High Court. And as explained earlier, if you don't get this leave, then you can go to the Court of Appeal to ask for leave. And if the Court of Appeal refuses, then that's it. You cannot appeal. An appeal has to be brought within 6 weeks. If it is not brought within 6 weeks, then an application has to be brought within 3 months to explain why you want your appeal to be brought in after time. If the person you are suing intends to oppose your application for leave out of time, then they have to file their opposition. Let's say you file your appeal on time and you serve it on the respondent. The respondent has a period of 3 weeks within which to oppose this appeal. And in opposing this appeal, then the matter is set down for what is called settling of the record of appeal, setting of the security for costs, as well as setting of the costs for the record of appeal. Both the appellant and respondent have to show up on the given date before the registrar of the Court of Appeal. And there, they will agree on the documents that form the record of appeal. And these documents would have been the documents that were filed at the High Court or Industrial Court, as the case may be. And in instances where oral evidence was given at that court, they can ask for the record of proceedings to be part of the record of appeal. And then the security for costs is set. The security for costs has to be paid by the appellant because they have dragged the respondent to court, and they pay this so that the respondent can get their costs in case the appellant is not successful in their appeal, as well as the amount necessary for settling of the record. It has to be paid by the appellant on a date that is set by the registrar. If the appellant does not pay the money on the given day, then their appeal will not proceed unless they bring an application to the court to be allowed to pay out of time. And it then follows the same sequence of the application, then you serve and the respondent gets to oppose and so on. When a matter is then given a date for when the appeal will be heard, the parties, being the appellant and respondent, are given times for when they will file the heads of argument, being where they set out the law in relation to why they're taking the position they're taking. So for the appellant to say why they believe the decision was wrong, and for the respondent why they believe that the decision of the High Court or Industrial Court was right. If the appellant does not show up to court on a date before the judges, and judges at the Court of Appeal sit in 3s or 5s depending on the matter. The only time a judge of the Court of Appeal sits alone is if they're hearing these applications for a matter to be heard out of time, or for the extension of payment of security for costs and so on and so forth, as well as deciding on whether or not an appeal can be heard as an urgent matter. If the appellant doesn't appear on any given date, then the appeal can be dismissed and the respondent may be awarded costs. If the respondent is the one that does not appear on a given date, then their opposition would fall away and the appellant can be given what they want. Whichever of the parties fails to appear, they have an opportunity to ask for leave from the court, and they have to do this to bring an application to set aside the decision of the court because they failed to appear within 6 weeks, where they have to explain to the court why they did not appear. If it is outside 6 weeks, then it's not simply showing the court why they did not appear. They have to have exceptional reasons. Once an appeal is heard and the Court of Appeal gives a decision, it can be different types of decisions. It can be a decision where they finally finish the matter. And because there is no higher court than the Court of Appeal, it means that would be the end of the matter. Sometimes the Court of Appeal can decide to take a matter back to the court whose decision you're complaining against, being the High Court or Industrial Court, for it to be heard again. Now, there are certain situations where a judge will give you an order in a matter and say to you that reasons will follow later. As soon as they give the order, then the 6 weeks for you to appeal starts running. And that is the reason why you are allowed to put before the court what is called holding grounds, where you explain that you are unhappy with the decision, but that because you haven't yet been given reasons for the decision of the court, you will be able to put in at a later date your proper grounds of appeal once you receive the reasons from the court for the decision that the court made. And it must be noted as well that an appeal is not an automatic stay. So by that I mean, just because you have appealed your matter does not mean that the order that you're complaining against or the judgment you're complaining against stops. I'll give an example. If the order is that you owe someone 1,000 pula and you appeal against that order, it does not mean that this person cannot get a writ of execution and go and attach your things. Meaning, if you file your appeal, you also have to ask for a stay of execution, because in terms of the law, an appeal is not an automatic stay of that order or judgment. I hope you got something of use from this video, and if you did, please make sure to like, share, subscribe, ring the notification bell so that every time I put up a new video, you get notified. Don't forget to follow me on my various social medias, being on Facebook, Twitter, TikTok, all called Botswana Thinking Law. And I hope to see you in my next video. Bye!